My name is George Williams from the University of New South Wales, and for the last 8 weeks I've been Dean of the Law School, so I come with great experience to this particular process. And look, I don't have an opening statement. I'm happy just to engage in discussion with you.
Thank you. I suspect you've been hanging around law schools for a while, though.
Too long, I think.
Perhaps we can start with just a general question, and that is, what's the future for lawyers and legal practice?
Okay, so we're starting off with an easy question, I see, initially. And I mean, the way I see it is that it's a sufficiently hard question to answer that the only thing I'm confident about at the moment is that the students that we are taking in our next round early next year are being trained for a profession that doesn't actually exist yet. And as to what that profession will be, I don't know. And what I am doing as part of my early role is I'm meeting with people across business, including all of the major firms, meeting with, say, Macquarie Bank this morning, through into a lot of legal technology startups as well, to get a sense of exactly that position as you're doing here as well. And what we can see are not so much as to what the profession will be as to the trends, whether they be outsourcing, which clearly will increase significantly given the technological costs being lowered to doing so, automation in terms of transactional work, which had been the bread and butter, of course, of the young graduate, also moving to lawyers becoming more of a business partner as opposed to providing what we might call more dedicated legal services. And they're three of the main trends, which are very obvious. The real question is how those things come together to produce a profession which, in particular, it's hard to see what the role of the entry-level graduate is going to be in that change profession. I think for very senior people, the relationships they've built will always be critical. I think a lot of the trust and relationship building will stay there. But what will be the role for the legion of law graduates who have come out into transactional work in a model that probably won't be sustained over the next decade? That's something I don't have an answer to, and I'm not sure the profession does either, from what I can tell at the moment.
So how is your university and how are universities adapting to this very uncertain landscape ahead of them?
I think the short answer is slowly and at this point not very effectively. And that I think mirrors also the experience of a lot of law firms which are going through a similar process where gazing into a crystal ball to train people for a way of doing business that doesn't exist yet is extremely challenging. So what I've done at this point is started by, as you're doing, with a lot of listening, finding out what the trends are. And my view at this stage is that we can't, it would be a mistake to radically transform our education to match, almost guess what people are going to need in that 5-year period. So what we can do, and perhaps the best thing we can do, is change our legal education to prepare people with a set of skills and a mindset that makes them intensely adaptable. So what I'm interested in doing is actually altering our law degree to build in a broader range of skills, technology obviously being part of that, but not exclusively. I think as part of that, the things we're looking at are, for example, whether we should have far greater opportunities for coding for our law students. That clearly already is working its way through a number of firms. And one thing I'm asking my faculty is whether indeed we'll have a compulsory subject in this area that will have mandatory technological exposure so that in 5 or 6 years' time we don't produce graduates who actually don't have clear exposure and familiarity with some of these options. But beyond that, it's actually, as I say, mindset and skills more broadly. So I think one of the most underappreciated skills is going to be resilience for young lawyers. And so what we don't want to produce is academically brilliant, brittle people who can't cope with industry change. And I think there's a danger that in preparing for a set profession that we do that we don't anticipate that we're not training people for a career, but multiple careers involving rapid technological change, which will accelerate over the next 10 years, but who knows over the 40-year life of a person's career really what is going to happen. So actually giving them a mindset and skills is important. Flexibility is a key part of that. I think another core skill that hasn't been valued often highly enough is just personal interaction skills, which are at the heart of a lawyer, whatever the technology, I think. And to do those things, what we've begun this year in quite a radical break for us is changed our entry standards. So we're at the point where we have a very elite entry standard, and that's good, but it's where we're letting people in who do exceptionally well in their leaving certificate, but that may be through a very narrowing of their skills, preparing for exams by way, for example, of writing essays for an English test and then putting it in their HSC. And what we're doing is introducing our law admissions test, which is designed to test for these other things: creative problem solving, resilience, flexibility, so that instead of culling people who may have slightly lower academic marks but higher propensity for the skills, we will actually reverse that, and we will let people in who may have a mark of 95, so nearly 5 points lower than we would otherwise let in, where they can show they have a broader range of skills that we think will be important to the sort of lawyers that the industry will need.
Can you just elaborate on the law admissions test and how that will work, and the areas that will be tested?
Sure, look, it's the first time we've done it, so it's, as the Thin Review had an article about 10 days ago, and we've essentially broken away from saying that the ATAR mark is the best sole indicator. There's a number of other things like bonus points and the like, but they're really at the margins. And this new test will be run by an educational authority where students will sit down, they will take a creative writing style exercise, which you can't pre-prepare for. It will ask them, for example, to solve a problem that they've been presented with for the first time and deploy whatever skills they think are appropriate for solving that problem. And we'll be testing lateral thinking, creative writing, broader communication, problem solving skills. It's been designed by an educational authority according to the skills that we're looking for. And what we'll have when we look at our entry is essentially two bits of information. One is the ATAR mark, and the second is this admissions mark based upon a different set of skills, and we will let people in with a lower ATAR mark where they demonstrate the other skills we're interested in. And it's designed quite explicitly to build greater diversity into the law faculty, not to cull in the way we do at the moment people who may have exceptional personal skills but not at that point the elite academic record. And it may well be, for example, that we take fewer people from elite private and public schools, but maybe someone like the Ducks of Dubbo or someone who has had a different set of life experience will be able to get in because they demonstrate a different skill set.
Do you think there are too many law graduates coming out of university?
Look, I think the short answer is yes, in that we have a demand-driven model, and it's understandable that students in large numbers want to study law degrees. And even though I fully accept that a good law degree, as we have, prepares people for a range of professions and skills, nonetheless there is a very obvious mismatch there between the vast number of law students being produced and the numbers of those who really have an expectation of working in the profession and the number who can actually be accommodated in the profession. And it's for that reason within our own university I've been making it very clear we should not be expanding our numbers. I think that would be a problem, and equally I think these sort of processes are important in terms of asking questions about, well, what is the connection between the law students coming in and the jobs that are on offer at the end.
Professor Hinchin's talked about the need for universities, the profession and the admission authorities to work more cooperatively. What's your view about that?
Yes, again, I think it makes perfect sense. One of the main goals I have is producing a faculty that's far more outward-looking. I think that we've done well in these areas, but in a pretty ad hoc way. I'd like to see more systems put in place that actually provide for far higher industry perspectives included within our faculty. I've practiced myself for 20 years as a barrister, so I've always been a practitioner and an academic. And for me, those things just marry together in helping us understanding this is a partnership in these areas. So for me, it's a no-brainer, absolutely. The only question is how we do it to use people's time effectively and to make sure that at our end that we actually can use that information in a way that drives change.
Professor Williams, I'd like to just hone in on one subject with you that we haven't actually explored with any of the witnesses so far, and that's resilience. You commented on resilience. The statistics that I quote when I talk about this topic, and I'm quite passionate about this topic, is the latest ones I've seen are a third of barristers and a quarter of solicitors are at risk of suffering some form of psychological
mental health issues.
I'm trying not to say mental health, but mental health issues. And students at the moment, the statistics in relation to the amount of psychological unwellness that's been suffered by students is quite substantial. And I just wondered, Professor Williams, if you could speak about the approach that University of New South Wales is taking in that space and what you're doing to help the students be resilient.
And look, yes, I can answer those both as to what we're doing now and what perhaps we might and should do in the future. In terms of what we're doing now, firstly, we're certainly well aware of the problem. And At the university itself, we have a lot of peer mentoring for students, we have counselling services, and we had a very broad range of support mechanisms for those people with us. But I think what we aren't doing and what we should do in the future is that we need to help students establish a better set of expectations about what success means in this area. I think that's part of it. And what I see as a practitioner myself is very often it's people have no chance of living up to what they perceive as being success in this area. And when you set people up almost to fail in those sort of circumstances, it's no surprise that we see a lot of problems moving from that, particularly in this area where there are relatively few legal jobs for a large number of people coming out. I mean, that mismatch itself is going to produce a very high degree of anxiety amongst people who have entered our doors with an expectation of a great legal job that frankly may not be there for them. So I think working in this space is very important. The law admissions test, I've said, is also important because if we focus almost exclusively, as sometimes there's a tendency to do, on academic brilliance, well, that's important. It's part of it, but it's not the only thing. And as we well know, that a great lawyer is often someone who's able with their client to deal with the vicissitudes of life that are thrown at them and deal with unexpected problems. And if someone doesn't have those skills, again, it can lead to real problems on the lawyer's side as well, because they aren't able to deal with, particularly with the massive changes coming through the legal profession. We need to have the people who are better able to deal with it and prepare them and help set their expectations in a way that make them understand that change is coming. They need to be able to roll a bit with that. Not everything is within their control. And I think the university sector, is a key part of helping people prepare for what's coming.
The question I had was, considering these new developments and skills areas that law schools are looking at teaching, how is that accommodated whilst also keeping the existing offerings? Does the current sort of core legal areas need to be reduced, or it can all be accommodated?
No, I think always when you look at, particularly if we were looking at introducing more mandatory technological exposure, then something has to give. The answer isn't just to add more in, because I think there is a danger here for law faculties that we do become too content focused. Content is important, but content is actually often more important for the skills that it instills, the analytical capacity and those sorts of things. And as we well know, in most areas, unlike my field of constitutional law, the law itself tends to change pretty rapidly anyway. So we haven't made decisions as to the give and take, but the discussion I've initiated at the university is going through another sort of curriculum process that focuses particularly on these issues: responsiveness, skills development, and actually working out, having now just gone through a more global process, we've integrated that into our curriculum. What's the next stage to do it? But I don't think the answer is to remove more electives, it's to recalibrate the core.